Lawyers and learners, today we are starting a very basic but very important topic in Hindu law, the question as to who is a Hindu. Now, at first, this question looks very simple, and you may rightly say that, sir, Hindu means a person who follows Hindu religion. This is correct, but from legal perspective, we need to be very precise and we need to give very specific definition. The question is very important because Hindu personal law will apply only to those persons who are treated as Hindus from the eyes of law. So before we study four major acts in this course, that is Hindu Marriage Act, Hindu Succession Act, Adoption, Maintenance and Guardianship, we must first ask this question, who exactly is Hindu as per law? Let us understand this step by step. Now, Hinduism is different from many other religions in one important way. It is not based on worshipping any single particular god. It does not prescribe any one particular holy book. It is based on several customs, and there are various schools of thoughts within Hinduism. Law does not define Hindu in a very narrow way. Actually, the legal definition of Hindu is very broad. And here comes the interesting part. The definition of Hindu is partly negative and partly inclusive or positive. Sounds too technical, right? But let me break it down and make it simple for you. The law says that if a person is domiciled in India and he is not a Muslim, not a Christian, not a Parsi, not a Jew, then Hindu law may apply to him unless it is proved that Hindu law does not apply to that person. Now think about this carefully. Suppose a person is living in India. He does not fall under Muslim law. He does not fall under Christian law. He is neither a Jew and nor a Parsi. In that case, which personal law will apply to him? Of course, the default fallback personal law, that is Hindu personal law, will apply on such person. This is where Hindu law works almost like a default fallback category. आप इनमें से कुछ नहीं हो तो आप हिंदू हो. That is why we say that the definition of Hindu is negative. This is one aspect. But I also mentioned that the definition of Hindu is also positive or inclusive. Let's understand this positive definition for a moment now. Positive definition means a person is a Hindu because he follows Hindu religion in any of its form or development. For example, the law includes Veerasaivas, Lingayats, Brahmo Samajis, Pratna Samajis, and those who follow Arya Samaj practices. The law also recognizes Buddhists, Jains, and Sikhs as Hindus. It also includes persons who are converts and reconverts to Hinduism, Buddhism, Jainism, or Sikhism. Now, this is the positive side. So, the definition of Hindu is negative because you are a Hindu if you are not Muslim, not Christian, not Parsi, not a Jew. But it is also inclusive because it brings many persons, sects, communities, converts and reconverts into the periphery of Hinduism. The legal meaning of Hindu is much wider than the ordinary religious meaning. Now let us understand the historical background as well. The root of the word Hindu is generally traced back to the word Sindhu or Indus. In ancient times, people living around Indus Valley civilization were described by foreign travelers and even invaders as Hindus. Over the time, word developed cultural, geographical, religious, and social meaning. Later, during British rule, Hindu law was treated as distinct branch of personal law, especially in matters like marriage, inheritance, adoption, and family relations. Now that we understand who is Hindu, let us understand what exactly is Hindu law. One simple answer may be Hindu law means the law which governs Hindus, but that is too simple and incomplete explanation as per law. Perhaps a more proper definition was given by John Dawson Mayne, who was well-known scholar of Hindu law, and he was even the Advocate General of Madras Presidency. Now, he gave a definition that is very long and verbose and difficult to remember, but it's a good one. Let me breathe before telling you that definition. Hindu law is a law of Smritis as expounded in Sanskrit commentaries and digests, modified and supplemented by customs and administered by the courts. Let me repeat it again. Hindu law is the law of Smritis as expounded in the Sanskrit commentaries and digests, modified and supplemented by customs and administered by the court. This is the definition given by John Dawson Mayne or John D. Mayne. Let us break it down into four parts, this definition given by John D. Mayne. First, Mayne says Hindu law is based on Smritis. Secondly, it explains It is explained through commentaries and digests. Thirdly, it is modified and supplemented by customs. And finally, it is administered by the court. So Hindu law is not only a religious text, it is a mixture of ancient text, interpretation, custom, judicial decision, and modern legislation. Now, after independence, Hindu law became much clearer because it got codified in the year 1955 and 1956. Parliament enacted four major laws related to Hindu personal law. These are the Hindu Marriage Act of 1955, the Hindu Succession Act of 1956, the Hindu Minority and Guardianship Act of 1956, and the Hindu Adoption and Maintenance Act of 1956. Hindu Marriage Act is of year 1955. All three remaining acts are from year 1956. These four acts give the statutory form to the modern Hindu personal law. For today's discussion, Section 2 of Hindu Marriage Act 1955 is very important. Section 2 tells us to whom Hindu Marriage Act applies. It applies to any person who is Hindu by religion in any of its form or developments. It includes Veerashaivas, Lingayats, followers of Brahma Samaj, Arya Samaj, and it also includes Buddhists, Jains, and Sikhs. It applies to persons who are domiciled in India who are not Muslim, Christian, Parsi, or Jew unless it is proved that Hindu law would not have applied to them. It also includes children born to Hindu parents and raised as a Hindu. For example, a child born to Hindu parents, or a child where one parent is Hindu, Buddhist, or Jain, Sikh, and is born and brought up by the member of those community. And it also includes converts and reconverts. So when you read Section 2 of Hindu Marriage Act, also understand its meaning in depth. Try to understand its purpose. The purpose is to give a broad, inclusive legal meaning to the word Hindu. It does not talk about which god the person worship. It does not ask whether person follows any particular religious custom. Instead, the law recognizes the wide and diverse character of the Hindu society. Now, let us come to a very important case law. The question, who is a Hindu, came before Supreme Court. The title of the case is Sastri Yagnapurushadji versus Muldas, Bhudardas, Vaishya, decided by the Supreme Court in the year 1966. The case is connected with Swaminarayan sect. Now, what happened in this case is that the followers of Swaminarayan sect argued that they were not Hindus in legal sense. They claimed that they formed a separate religious group and shall not be considered as Hindus. The issue became important because there was a dispute relating to temple entry of people who were Harijans. In fact, the defendant was a president of Mahagujarat Dalit Sangh who wanted to restore and protect the rights of Dalit to enter into Hindu temples. The question was whether the temple was a Hindu temple and whether the Swaminarayan followers were part of Hindu religion. The Supreme Court rejected the petitioner's argument that Swaminarayan sect was completely outside Hinduism. So the court had held in this case that Swaminarayan was a reformer and a follower of Hindu religion. Through this case, the court explained that Hinduism is not a rigid form of religion and it has a all-inclusive definition, and it comprises of various philosophies, various schools, and diverse customs. So merely because a community has a separate guru or a separate discipline, separate custom, it does not automatically become a separate religion and it remains the part of Hinduism. That is the legal principle that was laid in this case. Now, we have understood that Hinduism is not governed by one god, not governed by any particular form of custom or worship. It is understood by its broad civilizational, cultural, religious, and philosophical ethos. So remember, even Supreme Court has recognized Hinduism as a broad and inclusive, not a rigid religious system. Now let us sum up the answer to the question, who is a Hindu? Hindu is a person who is Hindu by religion in any form or development. A Hindu also includes Buddhists, Jains, Sikhs for the purpose of applying Hindu law. It includes converts and reconverts. It includes children who are born or brought up in Hindu, Buddhist, Jain, or Sikh family. And it also includes a person domiciled in India who is not Muslim, not Christian, Parsi, Jew, unless Hindu law is shown not to apply to that person. So the definition is broad and is partly negative, and at the same time it is inclusive. So the question, who is Hindu, is the starting point to study Hindu personal law, because only after answering this question we can understand who are the people who are governed by Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act, Hindu Minority and Guardianship Act. All these acts will apply to which group of people.